Judge Judy begins by hearing Ms. McLemore's claim that her neighbor's pit bull escaped from his property and attacked her small Shih Tzu, leaving the dog badly injured and resulting in expensive veterinary treatment. She is asking the defendant, Mr. Spikes, to cover $1,500 in damages. Mr. Spikes, however, insists he was away running errands when the incident happened and says his dog could not have been responsible because he claims he left the animal safely chained on the back porch. Ms. McLemore tells Judge Judy the incident occurred on December 21, 2014, sometime after 7:30 at night. She explains that she and Mr. Spikes had been neighbors for approximately 5 years. She owns a small Shih Tzu named Fuzzy, whom she has had since around 2005, while Mr. Spikes owns a roughly 3-year-old pit bull named Sanchez. According to Ms. McLemore, she was home that evening when her mother allowed Fuzzy to go outside. Before doing so, her mother says she called out for Sanchez because they were aware of the pit bull and were frightened of him. Sanchez did not appear from the back porch or around the house, so she believed he was somewhere out of sight. Once Fuzzy was released into the backyard, however, Sanchez suddenly charged toward him. Ms. McLemore explains that the pit bull was normally restrained by a chain attached near the porch, but on this occasion the chain apparently broke. She says Sanchez immediately went after Fuzzy, forcing her to call for her daughter because she was terrified of the dog. Her daughter rushed outside and helped separate the animals. Ms. McLemore describes the attack as extremely violent. She says Sanchez had Fuzzy in his mouth and was shaking him from side to side while the smaller dog cried out in pain. When the pit bull finally released him, Fuzzy ran back to his owner. She immediately noticed that one of his legs was completely limp and believed it was broken. They rushed him to an emergency veterinary clinic that was open overnight, where doctors confirmed that the leg had been fractured. The emergency clinic reportedly wanted more than $5,000 for surgery, so she was advised to take him to his regular veterinarian the following morning. Unfortunately, that doctor could not perform the operation immediately, leaving Fuzzy in severe pain overnight. Ms. McLemore says she had to give him pain medication and stay awake with him as he repeatedly cried throughout the night. Judge Judy then asks whether Fuzzy eventually recovered. Ms. McLemore says yes and presents photographs showing her dog before surgery, after the procedure, and in his current condition. Judge Judy looks at the final photograph and remarks that the dog is adorable. The attention then turns to Mr. Spikes, who says he had gone to the store when the attack occurred. He explains that his dog normally stays inside, but because the weather was pleasant, he decided to let him spend some time outside. Judge Judy notices that Mr. Spikes appears to be smiling while the witnesses describe the attack and directly questions him about it. He denies smiling, but Judge Judy is clearly unconvinced. She tells him that there is nothing funny about a neighbor being afraid of a dog capable of causing serious injuries, and stresses that owners of powerful dogs have a responsibility to keep them under control. Mr. Spikes maintains that Sanchez was chained when he left the house, and that the dog was still on the porch when he returned. Judge Judy immediately focuses on one major problem with that story. She asks whether the dog was actually chained when he left, and he says yes. She then asks whether he reattached the chain after returning home. He says no. Judge Judy learns that Mr. Spikes lives alone, which creates an obvious contradiction. If the dog was chained when he left, but he did not chain the animal after returning and nobody else lives with him, Judge Judy questions who could have removed the chain. Mr. Spikes attempts to explain that he had removed the chain from the dog's collar, but Judge Judy flatly tells him she does not believe his explanation. His repeated smile only makes her more suspicious. In the end, Judge Judy rules in favor of Ms. McLemore and awards her the full $1,500 she requested. The case is closed. The courtroom then moves to another dispute involving a performer, who says she was hired by the defendant to work at 2 events. Judge Judy asks what type of events they were, and the plaintiff explains that they were part of a Northern California regional rap competition called Rap for Peace. Her responsibilities included serving as an MC and performing some of her stand-up comedy material. The agreed payment for the particular event was only $50, which the plaintiff admits was already a very small amount. She says she completed her performance successfully, but the defendant failed to pay the agreed amount. Instead, she says he eventually handed her only $3 after the performance. Judge Judy points out that if the agreement was $50 and the defendant gave her $3, the remaining balance would simply be $47. The plaintiff argues that she deserves more because she had been working for very little, and claims there was also an understanding that she would receive better compensation for future shows. Judge Judy immediately stops her and explains that future performances are not the issue before the court. The plaintiff's complaint concerns the specific event for which the agreed payment was $50. She also says the agreement included meals and transportation. Judge Judy confirms that transportation was provided, and then asks whether the defendant agreed to cover her meals. He admits that he did. When asked whether he actually paid for those meals, he admits that he did not. The plaintiff estimates that her food expenses were around $10 to $20, but Judge Judy insists on a reasonable figure. She settles on $10 for the meal. That means the defendant owes $47 from the original $50 agreement, plus another $10 for food, bringing the total to $57. The plaintiff protests that she spent considerable time and effort trying to collect the money and insists she deserves the $250 requested in her lawsuit. Judge Judy points out that $250 is more than 5 times the amount the defendant actually agreed to pay. The plaintiff argues that $250 was what she should have been paid, but Judge Judy dismisses that reasoning as a case of shoulda, woulda, coulda. In other words, what the plaintiff believes she deserved is not the same thing as what the parties actually agreed upon. The plaintiff continues to argue that the defendant had promised to compensate her more generously for future performances. Judge Judy explains that an expectation about potential future work is not an enforceable contract simply because someone says they might pay more later. When the plaintiff questions why, Judge Judy gives her a blunt answer: because that is the law. She then warns the plaintiff that if she continues interrupting, she could be removed from the courtroom. Judge Judy next turns to the defendant's counterclaim, which she considers almost as unreasonable as the plaintiff's demand for $250. The defendant argues that the plaintiff was supposed to appear for 2 nights, but failed to show up for the first one. According to him, her absence forced him to take over some of her responsibilities, and allegedly caused him to lose money. He also says that when she appeared for the second event, there were hardly any people there, leaving him without enough money to pay her. Judge Judy finds the argument ridiculous. She points out that if he no longer wanted the plaintiff to appear for the second event, he could have simply called her and told her not to come. When asked whether he did that, he admits he did not and even acknowledges that he should have. Judge Judy explains that because he allowed the plaintiff to arrive, perform, and complete her responsibilities, the lack of an audience does not excuse him from paying her. The defendant accepted her services, and he cannot use the poor turnout as a reason to avoid an agreement he made. Judge Judy therefore rejects his counterclaim. At the same time, she makes it clear that the plaintiff's $250 lawsuit is also excessive. She awards only the amount supported by their actual agreement, $50 for the performance, minus the $3 already paid, leaving $47, plus $10 for the meal expense. The final judgment is therefore $57 for the plaintiff. Judge Judy declares the matter finished, and the parties are excused from the courtroom.